Pretty much every PC gamer can think of at least one controversial memory they have of the game design studio Electronic Arts, or EA. They are often considered the black sheep among the gaming community. There are many varying criticisms about EA across the board. The sad thing is the company really has always acted this way, as the lawsuit I'm covering today takes place in 2004. For those of you who don't know, in the gaming industry there is a phrase called the crunch culture. This term is used to describe the intense amount of extra work put on game design employees soon before the release of a game. In the crunch period, most employees are expected to work many extra hours beyond their initial agreement, being uncompensated in most cases. In 2004, however, an image design employee by the name of Jamie Kirschenbaum decided to file a class action lawsuit against EA for abusing this crunch culture. The lawsuit was named Jamie Kirschenbaum versus Electronic Arts. The plaintiffs were Jamie Kirschenbaum, Mark West, and Eric Kearns. They also were representing all others similarly situated and the general public. The lawsuit was specifically for image production employees at Electronic Arts, which essentially means everyone who was working on the visual aspects of game creation. Kirschenbaum was, at the time of filing, still working for EA. Mark West and Eric Kearns, however, neither of them were with the company at the beginning of the case. The defendant is Electronic Arts, the 8th largest game design company in the world. They have made several well-known game franchises such as The Sims and Star Wars Battlefront. As a result, they need to hire a large staff of image production and animation employees. The company is known as a magnet for lawsuits, having received many criticisms from game journals, general opinion, and dubious legal practice. This dubious practice includes their claims that their game developers and designers were exempt from overtime pay. This resulted in the majority of their employees working 12 to 13-hour days with only 8 hours of compensation. This is the reason Kirschenbaum decided to file a class action lawsuit against them. She believed EA's employees were being treated unethically and cheated out of pay. Kirschenbaum's main lawyers came from Schubert and Reed LLP, and the case was brought to the Superior Court of California, County of San Mateo. The conclusion of the lawsuit cost EA $15.6 million in damages to be distributed evenly to every image production employee covered by the class action lawsuit. The aftermath wasn't really anything particularly special, though. The industry didn't change much, and the lawsuit only had a small amount of media coverage when compared to other similar lawsuits. That's especially surprising if you take into account the size of Electronic Arts. GameSpot.com, however, was one of the biggest commentators on the lawsuit, covering the case from its initiation to its conclusion. The National Public Radio also released a document from the case, one which I'm using as a source, and the New York Times had an article on it. Several smaller blogs and journals also covered the topic, and several other journals and blogs have referenced the lawsuit in more recent years. If you want my opinion, EA is really a mediocre company. When you compare their products to similar products, they are just generally inferior. Time and time again, they have been found in a scandal. Their treatment of their customers and their integrity with consumer data is lackluster, and their treatment of employees is dubious at best. As a company, they are really not one to emulate, even though they have a large income. Alright everyone, stay safe with the pandemic going on, and I hope you have a great rest of the semester.